We've seen recent debates, sometimes heated, about critical race theory in schools. Our next guest tackles the topic in a recent issue brief for the Manhattan Institute. Jim Copland is Senior Fellow and Director of Legal Policies for the Manhattan Institute. And Jim, if people read your report, they can learn a lot about critical race theory and its history. We're going to focus this interview on ways to address critical race theory and regulate it or counteract it in schools. You have a piece of model legislation and also offer policymakers some ideas about do's and don'ts. Let's go in the order that your report has it and start with some of the don'ts. First of all, when you look at this, you say that we should not stifle the marketplace of ideas.
Exactly. And, when we looked at this, at this point, a majority of states have had some sort of bill introduced looking at critical race theory in educational institutions funded by the government or by the government agencies or what have you. 8 states at least have passed a bill on this subject. Florida has also acted administratively through its Board of Education. One of the critiques that was raised here, and folks, including those on the right, libertarians and conservatives, have raised various critiques. One of the critiques that's been raised is, well, we don't want to infringe on free speech, the marketplace of ideas. And our view is that in the higher education context, that's a good critique. There's certainly some case law out there. There's certainly some principles. Universities are supposed to have debate. I think universities can misbehave in this area too, but our model bill sort of stayed away from the universities where there's a lot of legal questions and focused on K through 12, because unlike the universities, K through 12, as we know, it's not that students lose their free speech rights at the schoolhouse door, far from it. But K through 12, when it comes to designing curricula, et cetera, is generally set by the state, by the legislature, or various committees delegated by the legislature, depending on state rules. And so it's not as if K through 12 teachers can just come in there and teach whatever they want, whatever they feel like. There tend to be curricula that are set. So we wanted an answer to that. Limiting it to K through 12 and really focusing on the speech rights of students and faculty and staff as well, because we're very uncomfortable with the notion that the government might compel speech, which the Supreme Court has also said is unconstitutional. The Supreme Court said a school district can't require you to say the Pledge of Allegiance in school, and there's reasons for that, and there's language in these sorts of decisions, and a lot of these sort of critical pedagogy, critical race theory inflected education approaches that we've seen in a variety of public schools have themselves sort of veered off into this compelled speech territory. And that's something we wanted to head off very clearly in our model bill.
Sticking with some of the don'ts, you also say that as policymakers do this, they shouldn't prescribe or discourage classroom discussions of race and racism, either in the past or the present. That should not be part of the discussion.
Correct. And I don't think that's the actual intent of legislators, by and large, that have been introducing these bills. I mean, I don't think there may have been at some point in time, of course, in certain schools and parts of the country, efforts to neglect various parts of history or misreport them. I don't think that's what anyone here is worried about. They're worried about the third grader, that their family sending off to school, being grouped together in various race groups or sex groups or various other forms of identity groups, and self-identifying as an oppressor. That's something very different from saying we're not going to teach about the history of slavery or the history of Jim Crow or the internment of Japanese Americans during World War II or something like that. And our belief is very much that schools should wrestle with these issues and try to teach them honestly and fairly and accurately. And the problem is, if you have a bill that sets up various mechanisms, say private rights of action to sue the school over this and that, and does so improvidently, you could sort of just make a lot of school administrators say something like, well, we don't want to get sued over this. It's going to be a hornet's nest. Let's just avoid these topics altogether. So I think it's important to have a narrowness in terms of what you're saying is prescribed and what your enforcement mechanisms are, so that you don't, in fact, do that. And that's something we strive for here.
You mentioned something that could cause some students discomfort. They'll be uncomfortable with what they're talking about. But one of your don'ts is also don't condition the curriculum on individual students' discomfort or distress.
Exactly. And of the bills we reviewed that have actually been enacted into law, none of them actually did this. A couple of them have been mischaracterized as doing this, but that's not, in fact, when you look at the actual bill language, what they're doing. And we explain that in the report. But there certainly have been bills introduced that would sort of step into this area. And it's important in our mind not to hinge this on an individual student's being uncomfortable or distressed. These are the sorts of things that folks on the conservative side of the aisle tend to be skeptical of, the notion that you have to have trigger warnings or safe spaces, or that people shouldn't be made to feel uncomfortable by reading the great works of literature or hearing honest assessments of history. We think it's important that our schools in fact, do convey things that may make students uncomfortable. Obviously, they need to be age appropriate, and we're not trying to set, the specific curriculum by grade level. That's far beyond the scope of this report. We just wanted to emphasize that whatever you're saying, it shouldn't be hinged upon an individual student's distress or discomfort.
I'm going to lump the last two together. One is straining school budgeting. You shouldn't do something that's going to end up causing a lot of financial distress for the schools. And the other is don't undermine educational pluralism in non-district schools. Both of those seem to be focused on let's not create overly broad problems for the schools themselves.
Right. I mean, we're not, listen, a lot of us are worried about this issue. They're in North Carolina, you've got a task force that's collected comments, and they've come up with stories that strike me as quite bad. That's been the case in a lot of states. We've seen lawsuits, we've seen complaints. But let's not get ahead of ourselves. What we don't want to do is, in our reaction to this, create some sorts of enforcement mechanisms that end up sucking school budgets dry, which inevitably would then lead schools to have to either cut budgets and cut what they provide or raise taxes. And those shouldn't be the end goals here. So we want to be sensitive to that. And so we suggest, maybe smaller districts can opt out of this or that requirement on transparency if they don't have the resources or things like that. And then in terms of school pluralism and educational pluralism, this is just a core value we believe in the Manhattan Institute. We believe that students should have more choices, not fewer. It's in North Carolina. The North Carolina Opportunity Scholarship is an example of this, that sort of empowers parents to take their dollars and educate their kids in a private school setting. A lot of parents are educating through homeschooling. There are charter schools that parents can opt into. These sorts of competitive opt-outs of a system where you have to go to one school controlled by the government based on where you live, which is going to be significantly a function of your family's budget and things beyond the child's control. I think these things are good. And so we wanted to go with a light touch with public charter schools, as long as they're not compelling speech with a First Amendment issue. We wanted to lay off charter schools as long as they're transparent and parents can choose openly and honestly. We think a variety of approaches could be appropriate there, including ones that we would think are otherwise bad. Same thing with private schools, even more so. I mean, there are clearly private religious schools that have faith-based requirements to be a member of the school community, et cetera. And if a private school wants to be the woke school or the critical race theory school and parents want to send their children to it, the state shouldn't prevent that, in our view.
Those were the don'ts. You've already sprinkled in the do's, but I'm going to recap them again. The policymakers should facilitate greater transparency, prohibit government compelled speech, and also clarify public school curricular choices. Anything else you want to say about the things that should be done?
Yeah, I mean, these were the focal points we came to. At the end of the day, we like transparency rules because that enables parents to become informed about what's going on in the school. And if they don't like it, they can act. They can act through withdrawing their child from the public school and either homeschooling or going to a private school or charter option. They can also mobilize at the grassroots level. Our schools tend to be locally controlled, so there are school board elections, there are public meetings, and parents can make their voices heard, but they have to be informed. One of the reasons why we think critical race theory in the schools emerged as such a hot button issue this year is not just that the schools took further steps down this road, and I think they did in the wake of George Floyd's killing last summer, and a sort of racial reexamination that was going on in various parts of society. I think they did take further steps. But also parents were more aware than ever of what was going on because so many schools had at least partial virtual education options. So parents were actually seeing what was happening in an unprecedented way. And we wanted to continue to facilitate that here and also provide opt-out opportunities for students and staff so that if parents didn't have the energy, resources, know-how, or capacity to change things and exit, and they couldn't homeschool perhaps, or they didn't have the resources for private school, they could at least opt out of some of these things if they found them problematic, the way a lot of school districts do for sex education and other sorts of subject matter. If the school district's misbehaving, the parents sort of have an opt-out, and that creates a sort of natural check on parents rather than having to try to file a lawsuit that may or may not win and will drag out in court and create a lot of other sort of angst in the community. And so that sort of transparency we think is important. The compelled speech point is really important. We don't think that it's inappropriate to teach various aspects of critical race theory. Some of them might be age inappropriate, but we don't think it's inappropriate for teachers to broach these subjects. We just don't think students should have to say, we agree with this normative worldview. And if they don't do that, they're not able to graduate or they get punished, or some of these examples we cited in the report. And that's where we wanted to really focus. But it is important to realize that public schools do have curricula that are set by legislators at the state level, and it's very much appropriate to sort of set boundaries there. And the problem with compelled speech in the schools compared to in other areas of government action is obviously a lot of what students do is in fact compelled speech. You're assigned a homework assignment. You're assigned an exam. It's compelled speech to say, well, we're going to punish you if you don't answer correctly that Shakespeare authored Hamlet or that Lincoln issued the Emancipation Proclamation. That is a form of compelled speech, and it's clearly not an unconstitutional form in the way that a loyalty mandate or a Pledge of Allegiance or an identification of this or that as an oppressor or a victim status would be. And so we think that to give the proper guideposts to the schools is invaluable and something that's totally appropriate for state legislatures to do.
We're going to get your take on what our state legislature is doing in just a bit. But first, some people who have been following this not particularly closely may say, well, what's it all about? What are we talking about? What's the concern? You actually set out 4 different core concepts or beliefs distilled from the various state bills that are things that should not be put forward as something that a student has to agree to. And I'm just going to list them real quickly. That the United States or the state is fundamentally and irredeemably racist or sexist, that individuals are inherently racist, sexist, or oppressive by virtue of their race or other intrinsic characteristics, that individuals are personally responsible for actions committed in the past by other members of the same race or other intrinsic characteristics, and that individuals' moral character is necessarily determined by race or other intrinsic characteristics. So basically, your model legislation is saying schools don't force students to have to adopt one of these things that probably all of us should agree shouldn't take place.
Exactly. And, this isn't a magic 4. I think the North Carolina bill has 13. We sort of tried to redact it down to basics, and we wanted to make them relatively few because some of them seemed a little redundant in some of the other bills. We distilled these from various bills that had actually been enacted into law around the country. But we also realized that some state legislatures aren't limiting what they're prescribing only to compelled speech. And they are actually saying, we don't want this actually taught in the classroom. And we think that the subset there would be a bit narrower than if you're limiting to compelled speech. Obviously, there's a whole heck of a lot of things that I don't think students should be compelled to affirm if it's some sort of identitarian, race essentialist type of viewpoint. But you might teach these theories in the classroom. And so because we wanted our model legislation to be adaptable by various state legislatures with different approaches, and we sort of bracket in there, a state that wants to go further than merely limiting to compelled speech, and state legislators clearly have this power in the K through 12 context, could do so. And so for that reason, we sort of kept it fairly narrow. But I think these are pretty unexceptional claims, and I think it's the sort of thing, I don't know who wants to defend taking the contrary view. I mean, I guess you could certainly criticize the United States or the state government in various ways. Certainly there have been race has been embedded in nefarious ways throughout national and state history in a lot of places, certainly nationally and in most states. So you could certainly do that, but to force the students to affirm that the U.S. is fundamentally or irredeemably racist or sexist was too far for us. And then sort of these individual-based, affirmations, teaching an 8-year-old kid you're an oppressor because of the color of your skin, to us, it's just anathema. And it's the sort of thing that ought to be pretty obvious that no reasonable person would want a teacher to force upon a young person.
You've been looking at these types of bills across the country and at North Carolina's. We've already referenced it. How does North Carolina's bill, as encompassed in the Senate version of House Bill 324, how does that stack up to what you're looking at throughout the country?
I think it is closer to the gold standard, and obviously, I think my view of this is pretty close to the gold standard, or I wouldn't have published. I think closer to the gold standard than most, if not all, the other bills we've looked at. I guess this just passed the state Senate yesterday, and so that's the version I've reviewed here. But been looking at this in various iterations, and the North Carolina bill really does focus on those two core planks that we really focus on as well: compelled speech and transparency. And so North Carolina lists, I said, 13 different things that cannot be promoted by the public schools, including things like a meritocracy is inherently racist or sexist, or an individual's moral character is necessarily determined by his or her race or sex. And so, these words in there that I think are important that are there. But I want to emphasize that when it says promote, it doesn't mean that a teacher can't broach these topics or talk about people who have contrary views here in the classroom, which I think will be important, at least in an age-appropriate classroom, for teachers to be able to discuss. The bill specifically defines promote as compelling students, teachers, administrators, or other school employees to affirm or profess belief in the concepts described. In other words, you can say so-and-so says this, but you can't condition what the student's education experience or the teacher's job or whatever on basically saying we believe this, and if you can punish the student for not holding that belief. So these are normative beliefs that you're not punishing students for holding, which is entirely consistent with the Supreme Court's view of the matter in West Virginia v. Barnett, when they decided almost 80 years ago that you can't compel students to recite the Pledge of Allegiance in the classroom. You can recite the Pledge of Allegiance, but you can't compel students to do so. They have the right to opt out and not do that. This is entirely consistent with that. And then the second big piece of this bill is the transparency bill, which is quite similar to the one in our model bill, which is, of course, based in part on other pieces of legislation that were out there. And this is just sort of notifying the Department of Public Instruction and making available on the public schools website after a given period of time various of these materials that cover these topics. This is precisely what we ask for in our model bill. We think it will inform parents and allow parents to complain, to make their voices heard, to talk to the school boards, to talk to the school administration, and if they choose to opt out and find other options for their children. Now, there's not in this bill an express opt-out provision the way we provide for it in our model bill, and it's something the legislature may think about down the road, how they want to build that in. But by and large, I think this is an excellent bill, and quite closely tracks the model bill that we put out yesterday.
So basically, bottom line on this, if North Carolina is going to do something about critical race theory, something like the proposal in House Bill 324 is the right way to go.
I think it's the right way to go. It's totally consistent with the values and principles that we talk about in my issue brief. It is mind-boggling to me that I think this passed on strict partisan lines, which leads me to believe there may be a gubernatorial veto and it may be hard to override it. So it may be, in fact, hard ultimately to enact this into law. But I find it somewhat incredulous that a legislator in good faith would think it's okay to compel students to believe these sorts of very normative, personalized beliefs, as a condition of their schooling or employment. So I hope there's a reconsideration there when you actually look at the language there. This isn't barring the teaching of various of these concepts. It's barring the compulsion to affirm belief in various normative concepts. And that's something that I think already would be barred in most of these cases under clear First Amendment doctrine. But it's clearly something that school administrators are struggling with because, as I said, students can be compelled to give the right or wrong answer in exams and take part in classroom exercises all the time. So I think it's very important for the legislature to set guideposts where it looks like schools have been misbehaving.
If you'd like to learn much more about this topic, including a lot of the history of critical race theory, how it came about, how it came to be in the schools, you'll want to read this issue brief from the Manhattan Institute titled How to Regulate Critical Race Theory in Schools, including a primer and model legislation. Its author is Jim Copland. He is Senior Fellow and Director of Legal Policy at the Manhattan Institute. And I should mention, a North Carolinian. Jim, thanks so much.
Thanks so much for having me, Mitch.